Retired Supreme Court Justice blasts office of CJN, says it is deliberate, leaving out Southeastern panel that determine presidential election appeal. Welcome to the news and please subscribe to our channel. Honorable Justice Musa Dattijo Mohammed, who bowed out of the Supreme Court on Friday, have attained the statutory retirement age of 70. Opened a new conversation on the enormous powers the Office of the Chief Justice of Nigeria, CJN, wields. His Lordship at the valedictory session, attended by former Head of State, General Abdulsalami Abubakar, retired, and his wife, Honorable Justice Fati Lami Abubakar, retired, a former Chief Judge of Niger State, Honorable Justice Sidi Baje, GSC, retired, Area of Lafia, and one-time Justice of the Apex Court, Attorney General of the Federation, Prince Lateef Fagbemi San, President of the Nigerian Bar Association NBA, Mr. YC Mikayu San, Chief JK Gazama San, who represented the body of senior advocates, Bosan, a host of other dignitaries, said that the CJN deliberately refused to replace justices of the Apex Court from Southeast and North Central that either retired or passed on. When I say today, the North Central region that I represent will cease to have any representation until such a time new appointments are made. My Lord, Honorable Justice Ejemobi Eko, who also represented the zone, retired on the 23rd of May 2022. It has been a year and 5 months now. There has not been any replacement. With the passing of my Lord, Honorable Justice C.C. Nweze on 30th July 2023, the Southeast no longer has any presence at the Supreme Court. My Lord, Honorable Justice Seveta Mwali Unguta died on the 7th of March 2021. There has not been any appointment in his stead for the Southeast. To ensure justice and transparency in the event of presidential appeals from the lower court, all geopolitical zones are required to participate in the hearing. It is therefore dangerous for democracy and equity for two entire regions to be left out of the decisions that will affect the generality of Nigerians. This does not demonstrate federal character as required by our laws. Although it can be posited that no one expected the sudden passing of Justice Nweze, JSC, yet it has been 2 years and 7 months since the previous justice from the Southeast died and no appointment was made. Ditto for the replacement of Justice Eko of North Central, who exited nearly 2 years ago. Honorable Justice Sidi Baje, JSC, how His Royal Highness the Area of Lafia from the North Central had earlier voluntarily retired. He is yet to be replaced. Also, it was a clear ab initio that I would be leaving the court this day on attaining the statutory age of 70. It is then not in doubt that there has been sufficient time for suitable replacement to have been appointed. This did not occur. When on the 6th of November 2020, the Supreme Court, for the first time in its history, got a full complement of 21 justices with the swearing in of 8 justices. Little did anyone know that we were only a few steps unimaginable with regression. As it stands, only the 4 geopolitical regions, the Southwest, the South-South, the Northwest, and the Northeast, are represented in the Supreme Court. While the South-South and the Northeast have 7 justices, the Northwest and the Southwest are fully represented with 3 each. Appropriate steps could have been taken since to fill outstanding vacancies in the Apex Court. Why have these steps not been tenuously taken? It is evident that the decision not to fill the vacancies in the court is deliberate. It is all about the absolute powers vested in the office of the Chief Justice of Nigeria and the responsible exercise of same. The powers of the Chief Justice of Nigeria. As presently structured, The Chief Justice of Nigeria, CJN, is the chairman of the NJC, which oversees both the appointment and discipline of judges. He is equally chair of the Federal Judicial Service Commission, FJSC, which recommends those selected for appointment to the NJC, the National Judicial Institute, NJI, and the Legal Practitioners Privileges Committee, LPPC, which appoints Senior Advocate of Nigeria. In my considered opinion, the oversight functions of these bodies should not rest on one individual alone. A person with absolute power, it is said, corrupts easily and absolutely. As chair of NJC, FJSC, NJI, and LPPC, appointment at council, board, and committee members are at his pleasure. He neither confers with fellow justices nor seeks their counsel or input or any matter related to these bodies. He has both the final and only say. The CJN has the power to appoint 80% of members of the council and 60% of members of the FJSC. The same applies to NJC and the LPPC. The power of being appointed a judge of any court rests squarely on him. Such enormous powers can be abused. Such enormous powers are effortlessly abused. This needs to change. Continued denial of the existence of this threatening anomaly weakens effective judicial oversight in the country. By the provision of paragraph 20 of part 1 of the 3rd schedule to the 1999 Constitution of the Federal Republic of Nigeria as amended, the NJC shall comprise the following members: the Chief Justice of Nigeria, who shall be the chairman, the next most senior justice of the Supreme Court, who shall be the deputy chairman. Regrettably, the next most senior justice of the Supreme Court, likely deputy governors of state, shorn of any official function except at the pleasure of the governor, is neither consulted on anything, nor does he have any official function. His job as number 2 is purely as the CJN pleases. It is